The Erie Doctrine, in its basic form, is actually rather easy, and that might come as a surprise to you after sitting through lectures on Erie in your Civ Pro class or speaking to others who have gone through the process. The reason is that law professors like getting into the weeds. They like focusing on very interesting questions about Erie Doctrine that come up very rarely in real life. When law professors do that, students tend to lose the forest for the trees. But it turns out that the forest is really a lot easier to understand than the trees are. Not only that, but if you focus on the forest, I think you'll find the trees more manageable and more understanding as well. So we're going to focus on the forest. That's not to say that the details aren't important, and we're going to discuss some of them. But my primary objective in these discussions is not to tell you everything that you might need to know about the Erie Doctrine. That, after all, would be focusing on the trees. Rather, my objective is to demystify it for you, to make it simple, and to enable you to work with it more easily, more competently. Erie means simply this. Federal courts must apply state substantive legal rules when adjudicating state law claims. That's basically it. Again, federal courts must apply state substantive legal rules when adjudicating state law claims. That means that when a federal court hears a tort, contract, or property dispute, or a dispute that grows out of state statute otherwise, state court decisions govern the case. The state Supreme Court, and not the U.S. Supreme Court, is the final authority. That means that if the state Supreme Court has already spoken about the issue, and that prior decision governs our current decision, federal courts have no authority to overrule the state court decision and won't. They won't talk about it. They'll simply try to apply the state law as it's been decided. However, federal procedural rules will govern process. So if it's a substantive question, you apply state law. If it's a procedural question, use federal law. That's Erie. Now, of course, differentiating between substance and procedure can be quite complicated in tough cases, and that's where a lot of these confusing details come in. But let's put that discussion off for now. In the vast majority of cases that your typical litigator is going to see, it's not really that complicated at all. If you want to know whether someone was negligent, or whether a contract has been properly formed, or whether a state government official has acted outside the scope of his powers, look to state law. If you want to know what and where you have to file a particular document, you look to federal law, federal procedural law. Another quick point to try to keep you focused on the forest rather than the trees. Erie cases are nearly all diversity cases. That is, the matter of subject matter jurisdiction, they fall under the diversity category. And your professor in the cases themselves might actually refer to Erie as being somehow related to the diversity rules. That's just misleading, unfortunately. While most of the Erie cases are diversity cases, Erie has nothing to do with diversity. It has nothing to do with subject matter jurisdiction. It's not dependent on diversity. It's not dependent on subject matter jurisdiction. Rather, any time a federal court is asked to adjudicate a state law matter, it uses state substantive law. That means if the federal court has supplemental jurisdiction, for example, over a state law claim, it will apply state substantive law. A brief note about policy before we move on to some of the details. Erie is motivated by a desire to ensure consistency between federal and state courts, ensuring that they are both, that is, both the state and federal courts are using the same body of substantive law, and to minimize prejudice caused by forum shopping. We want to give the plaintiff the right to choose where to sue, but we don't want to give him the right over substantive law as well, to choose which substantive law is going to apply, at least to the extent we can limit it. If the federal courts and the state courts in the same location were applying different substantive law, it would make it a lot easier for the plaintiff to determine the outcome of the case by giving him the right to decide where to file. So even if it's not immediately obvious, Erie is actually a very important part of the fairness puzzle in ensuring a fair legal system. Next, we're going to move on to some of the details of the Erie Doctrine.